Hello everyone. Now we have reached to Article 25, Right to Freedom of Religion, titled The Freedom of Conscience and Free Profession, Practice and Propagation of Religion. Clause 1, subject to public order, morality, and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. Clause 2. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law. Subclause A. Regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. Subclause B. Providing for social welfare and reform or the throwing open of Hindu religious institutions of a public character to all cases and sections of Hindus. Explanation 1. The wearing and carrying of kirpans shall be deemed to be included in the profession of the Sikh religion. Explanation 2. The subclause B of clause 2, the reference to Hindus, shall be construed as including a reference to persons professing the Sikh, Jain, or Buddhist religion, and the reference to Hindu religious institutions shall be construed accordingly. So, Article 25 of the Constitution guarantees the following freedoms to all persons. That is, first, right to freedom of conscience. It is the inner freedom of a person to mold his relation with God in whatever manner he likes. One can have any kind of belief or faith. Two, right to profess, the right to declare freely and openly one's faith. Third, right to practice, to perform religious duties, rites, rituals, and ceremonies. Fourth, right to propagate. Propagate means to spread and publicize one's religious views. However, these rights are not absolute and are subjected to public order, morality, health, and other provisions relating to the fundamental right. About secularism, in SR Bombay versus Union of India, AIA 1994, the nine judges bench of the Supreme Court held that a secularism is a basic feature of our constitution. The state treats equally all religions and religious denominations. Religion is a matter of individual faith and cannot be mixed with secular activities. The Supreme Court also stated that the state shall not establish or foster any religion. Justice Sawant, while discussing the concept of secularism in the judgment, stated that religious tolerance and equal treatment of all religious groups and protection of their life, property, and place of their worship are the essential part of secularism enshrined in our constitution. About essential religious practice, the doctrine of essential religious practice enshrined in Article 25, which is commonly known as the doctrine of essentiality, was invented by a seven-judge bench of the Supreme Court in the case of the Commissioner Hindu Religious Endowments Madras versus Sri Lakshmidra Tirth Swaminarayan of Sri Ur Mut year 1954. The Supreme Court held that the term religion will cover all rituals and practices integral to religion and took upon itself the responsibility of determining the essential and non-essential practices of religion. In the case of Dargah Committee, Ajmer versus Sayyid Hussain Ali, AIR 1961, the Supreme Court observed that in order that the practices in question should be treated as a part of religion as they must be regarded by the said religion as its essential and integral part. Otherwise, even pure secular practices, which are not an essential or an integral part of religion, are apt to be clothed with a religious form and may make a claim for being treated as religious practices. Similarly, even practices, though religion though religious, may have sprung from merely superstitious beliefs and may in that sense be extraneous and unessential accretions to religion itself. The protection must be confined to such religious practices which are an essential and integral part of it and no other. About noise pollution in Church of God versus KKR Majestic Welfare Colony Associations, AIA 2000, the Supreme Court held that the use of microphones and loudspeakers to recite prayers was not an essential religious practice and therefore not constitutionally protected. In the case of Commissioner of Police versus Acharya Jagdishwaran Vedut, 2004, The Supreme Court held that the Tandav was not an essential practice of Anand Marga faith. The Supreme Court observed that the essential part of a religion means the core beliefs on which the religion is founded and those practices which are fundamental to the followers of the religion. In order to determine whether or not a particular practice is an essential part of a religion, the test must be whether the absence of the practice itself fundamentally alters the religion. The protection guaranteed under Article 25 and 26 of the Constitution is not confined to matters of doctrine or belief, but extend to acts done in pursuance of religion and therefore contains a guarantee of for rituals, observances, ceremonies, and modes of worship which are essentially or integral part of religion. In Adi Shiva Nala Sangam versus Government of Tamil Nadu 2016, an amendment to the Tamil Nadu Hindu Religious and Charitable Endowments in Constitutionality in 1970 abolished the practice of appointing religious office holders on hereditary basis, and the constitutionality of this amendment was upheld by the court in 1972 in the Shishamal case. However, in 2006, a government order was issued directing that archakas of the temples were to be appointed without any discrimination stemming from customs on the basis of caste or creed. This government order was then challenged on account of violation of the religious freedom under Article 25 by interfering in the essential matters of the denomination of archakas. Relying on the decision of Seshamal, the court reiterated that though appointment was a secular function, the denomination of the archakas must be in accordance with the agamas. The agamas restricted the appointment of archakas from particular religious denominations. Archakas are required to be appointed as per the agamas, and this embodies a long-standing belief that has come to be firmly embedded in the practices immediately surrounding the worship of the image, and therefore such beliefs practices constitute an essential part of the religious practice. The right to equality of opportunity under Article 16, Clause 5 is not violated if a religious office bearer is required to belong to a particular religion or denomination as per the essential tenets of such religion. However, the court did go on to hold that religious treaties like the agamas must conform to the constitutional mandate and not practice exclusion on the basis of constitutionally prohibited criterion like caste. About prohibiting women to enter Dargah contravenes Article 14, 15, and 25, and Dr. Noor Jahan Safia Niaz and another versus State of Maharashtra and others, 2016. The Bombay High Court held that the ban imposed prohibiting women from entering the sanctum sanctorum of the Haji Ali Dargah contravenes Article 14, 15, and 25 of the Constitution. Therefore, we order restoration of status quo ante, that is, women be permitted to enter the sanctum sanctorum at par with men. The state and the trust should take effective steps to ensure the safety and security of women at the said place of worship. About triple talaq being unconstitutional, in Shaira Banu versus Union of India 2017, the majority of 3 is to 2 of 5 judge bench of the Supreme Court set aside talaq biddat or instant and irrevocable talaq as manifestly arbitrary practice which is not protected by Article 25 freedom of religion of the Constitution. This form of talaq must therefore be held to be violative of the fundamental right contained under Article 14 of the Constitution of India. The court hence held that the Muslim Personal Law Shariat Application Act 1937, insofar as it seeks to recognize and enforce triple talaq, is within the meaning of the expression law enforced in Article 13, Clause 1, and must be struck down as being void to the extent that recognizes and enforces triple talaq. In about Sabrimala temple case in Indian Young Lawyers Association versus State of Kerala 2019, popularly known as Sabrimala temple case, the Supreme Court held that the temple's practices of excluding women from entering the temple is unconstitutional. It held that the practice violated the fundamental right of freedom of religion, Article 25, Clause 1 of female worshippers. It struck down Rule 3, Clause B of the Kerala Hindu Places of Worship Act 1965 as unconstitutional. Rule 3B allowed Hindu denomination to exclude women from public places of worship if the exclusion was based on custom. So the about the Sabrimala temple case, the practice of excluding women from entering the temple was held unconstitutional by the Supreme Court.